The point that I'm making is that we both relied upon the 2018 constitution, but the commission in its order, without letting us know during the argument, said that the 2018 constitution is not recorded in the election commission. Never put it to us, never told us, not their argument, not my argument. Both argued on the 2018 constitution, and the commission, without ever informing us, says that constitution is not on our records. Anyway, so even though we have majority in the organization, they say we will not consider that. So they don't consider the organization, they consider this majority of those who are, according to us, disqualified, and give them the symbol. So you move from the speaker to the election commission, and then from there, where do you go? So obviously, in terms of paragraph P, it's the political party which issues the direction, not the legislative party. And the direction is issued through the leader of the political party, normally the whip or the leader of the political party. Such person authorized. So therefore the political party will authorize such person, and he is the whip. The whip term is not used in the 10th schedule, as you will notice. The term used is direction. Normally, whose permission has to be obtained if I want to vote against the whip? Political parties. And political party is outside the house, not within the house. Within the house are only legislators. So you'll have to go to the whip, you'll have to go to the whip, or the person authorized, okay, look, I want to vote against, or I want to make a speech against. I don't agree with this bill. And sometimes, brothers, actually whips do agree. It has happened so often with us. You say, no, these particular clauses, I don't allow me to speak, but I will vote for you ultimately because I don't want to violate the whip, but allow me to speak. And sometimes we are allowed. So paragraph 3 as it then stood operated on the assumption that there is a split in the original political party. A split in the legislative party would not have been a defense, even if it is more than 1/3.
There has to be a split in the original political party.
Now, how does that split happen? Because he makes a claim. Before all this happens, demonstrates in the claim that a split has occurred, calls for a meeting of the original political party, has a faction, has a resolution passed, breaks away, mothers, and then if he is 1/3, it's a defense. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, the 1/3 is in relation to the group representing the legislative party.
Yes, I agree, mother. Mother, that split may be minority, majority, it doesn't matter.
So long as, there is a split.
There is a split.
In the original political party.
Correct. So, that's not the case here, mothers. On 21st of June, they were in Gujarat and they were in the Northeast. Only the legislative members. And they never said there's a split. They said, we are the Shiv Sena. So that claim was also not there. That if you are disqualified, you can't be a minister. Now your disqualification is pending. Matter is before the constitution bench. Matter is before the speaker, whichever it may be. And you are appointed by the governor.
And also there's a provision under the Representation of People's Act where they can't contest again.
That's right. Not for this, mothers. Not for the 10th schedule. That is for other corrupt practice. There is no period here. That's why I say this is subject to challenge. There, mothers, if it were for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Now, mothers, what is happening in a ordinary case of a dharna on a road, a trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as a split is concerned in the legislative party.
Mr. Sibal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No.
But that has to be resolved outside the legislative party. That cannot be still, according to you, resolved within the fold of the legislature party.
No matter that question doesn't arise in this case because
No, I mean, we're not on this case, but that question as to who represents
that will happen outside the House.
That will happen outside the House. That cannot be resolved by the number of legislators within the House.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the House is actually given in a judgment of this court in Brahmanand Reddy.
That's of the internal constitution.
That's right. You have to call a meeting. You have to raise the issues. For 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes.
But the forum is...
You have to follow those bylaws. You have to call a meeting. You have to resolve that issue. And then you can do all this, Manoj. When paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections, toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of a dispute that will arise and it will go to courts and the courts will decide in their own time. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there's a split in the political party which is not even addressed, which is not even claimed. What is claimed is that we are the party. Now, we are the party can't be claimed within the legislative party.
For 2.5 years.
He was the minister. This very government never raised any issue. There is no public document saying that he is dissenting or he is a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House. Till 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do, the only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164, 1B now gives you a way out. Instead of defecting, you can resign. And then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office. No governorship, no remunerative post.
Kind of cooling off.
I'm sorry?
Cooling off of sorts.
Yes. Even in 361, Malaj, in fact, disqualification for appointment on remunerative political post. Capital B, Malaj. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment, Malaj, was very careful in trying to sort of settle part of the problem. But one thing was clear, they did not allow for bulk defections. So, Malaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he and any other members of original political party have become members of such other political party, that is, they merge into that party, or as the case may be, of a new political party. Both of them may form a new political party formed by such merger.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes. No, but if he has not merged, he can form a separate. He will belong to the original. Supposing two parties merge and form a new party. Correct, Malaj? And he belongs to the original political party on which he won the election. He will continue to be the original political party.
I think Amar Singh's act like that.
Amar Singh, yes. He will continue with the original political party. So, if there's a new political party formed pursuant to merger, and I belong to the original political party on the basis of which I was elected, I continue to be in that original political party. Now comes the problem. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of a house shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Now, Malaj, if 2/3 of the members don't agree, then there is no merger as far as the legislators are concerned. First, the merger takes place. Then the question arises whether you are 2/3 or not. If you are 2/3 and you agree, it is fine. It's a defense. If you are not 2/3, Malaj, then you can be a separate group. So 2/3 happens to be a defense after the merger.
This deemed is also very important.
Yes.
Because what 10th schedule does is that it doesn't create a new category.
Yeah.
By saying deemed, it is relating back to the position of the assembly as it were
Yes.
when legislators got elected and come to the assembly.
Yeah.
That position will be deemed instead
Yes.
of creating a new category.
Correct. So 2/3 of the member, less than 2/3 of member, Malaj, question defense doesn't arise. But if 2/3 of the members agree, then Malaj, that's a defense. That's a perfect defense. So Malaj, looked at it from any standpoint, these 40 people have no defense under the 10th schedule. They don't claim that there's a merger. They say that they are majority in the legislative party. They claim that because of that majority, they can change the whip. They claim that they can change the leader of the house. They can call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. And so what happens, Malaj, to the political party to which he belongs? What morality are we talking about? What conscience, Malaj, conscientious objectors are we talking about? Conscientious defectors is the word that I used last time. Malaj. And you don't raise a voice for 2.5 years. You are the leader. You enjoy the fruits of ministership. And suddenly you say that, look, now I am free to do what I want. I can join up with the BJP. I can go to Guwahati or wherever I want to go to, and that's it. So the question that your lordships will have to ask, Malaj, how does the 10th schedule come to their aid at all? Under what provision of the 10th schedule can they have a defense? The schedule doesn't give them a defense. Whether it's a minority bulk moving away or a majority moving away, which is when we last time, Malaj, were discussing this matter, this is what I mentioned. That the 10th schedule doesn't make a distinction between majority and minority. It just ensures that this habit of bulk defections, which is destroying the polity of this country, and by which elected governments can be overturned. The objective is that you should not allow an elected government to be overturned. That's the fundamental premise on the basis of which paragraph 3 was deleted. You cannot destabilize government. And if you uphold such an act to a judicial process, you are enabling future defections and therefore destabilizing elected governments, which has far-reaching consequences for the polity of this country. That's the issue that your lordships have to decide. The governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one criteria on the basis of which he will swear in. 2, Malaj, he will ask the question, which party do you belong to? He's naturally have to ask. I'm sure he will know that before even he asks that question. So he knows, Malaj, that the Shiv Sena is not before him. On the 30th, he knows Shiv Sena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, or the BJP along with the 39 rebels will oust the government and will support the new chief minister. He also knows, Malaj, there is a disqualification petition pending. So your lordships will have to decide for the first time in situations of this nature when there's already an elected government in place and there is a taint, alleged taint of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done two things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the chief minister. The court has given you time to the 12th of July. Please first file your reply on the 12th of July. See the outcome of those proceedings. And if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted.